LAWsome by Consultwebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
Hello, today on our show, we're speaking with Dr. Carla Rydholm, Director of Product Management at Lex Machina. We'll be discussing how the right data can give litigation attorneys a competitive edge in winning more lawsuits. This includes determining which clients to pursue, what claims to include in a complaint, and when to settle, among many other things. Carla, so happy to have you joining us today. How are you?
I'm great. Thank you so much for hosting today, Tanner.
Absolutely. So, Carla, let's just jump right in. Data is everywhere, it seems like, especially in today's legal world. And today in this conversation, we're focused on using data in litigation specifically. So, with that, can you give us an overview of the types of data that litigators can focus in on to win more lawsuits?
Well, first off, use data. That's what I'll leave with. So legal analytics, so using data comprehensively for what's happened before in the courts, really knowing what's happened to anticipate the behavior of the judge you're in front of, the law firm you might be competing against, or perhaps as an adversary, other attorneys and parties. That's all data that's out there. And really thinking on use that data just like you would as an attorney. What's happened before? How can I use that to my advantage? So in terms of the kind of data, really there's a lot that can be done. The courts have a really rich history of all the cases that have happened before. So what is out there now, legal analytics, it's comprehensive, tagging and classifying what's happened, really creating data sets to allow you as an attorney to uncover insights. So use that data to win more clients, in a client pitch, for example, to complement other aspects of your pitch, and then use data to win cases for your clients. So winning in court, win the best negotiation, just design that winning approach using data.
That's great, and that's clearly why all this matters. We get so lost in being in marketing and having access to seemingly infinite data. It's easy to get lost, but in that it's often all too easy to kind of just set it aside because it's difficult to make sense of. But clearly there is tremendous value not only for these litigation attorneys that may be listening, but also obviously for their clients. And so I'd love to explore that more deeply with you. And so digging into that detail, can you give us a story maybe a couple stories on how data has given litigation attorneys a competitive advantage that helped them win a particular case or a lawsuit for their client? Sure.
So in thinking through that complexity, or just that there is a lot of data that you mentioned, there's one story that comes to mind, and this has to do with a case that had fairly technical details and associated legal analysis that relates to what was going on. And this involves really a partner who was trying to win on summary judgment, or maybe even judgment on the pleadings early on. And so looking at what that judge has done before, and will that judge make dispositive rulings, early on, or assessing, is that a judge that prefers to let things go to trial? That's a real bellwether in setting your client expectations about, well, why are we spending so much time on this phase? It's like, well, we can win here. This has happened before. This judge, for cases like ours, has made a ruling that's favorable on what we're going for here. So really going from the big picture, talking with the client about, well, we can anticipate this judge potentially granting in our favor, and then drilling down from that big picture, from all the cases and the trends or the data highlights into specific legal arguments, like dig into the underlying cases. Anytime you see a number, it's like, oh, well, dig in and take a look to really understand how you can leverage. If there was a grant in a case that looks like yours, get in the details, get in the documents. So that big picture down to the specific underlying cases is just another way to draw on litigation history to win. And then, Tanner, I have a second story, but it's quicker.
Sure.
So this has to do with setting client expectations as well. And it's simple. It's really, with state courts especially, And that's an area that the company that I work with, Lex Machina, we're getting deeper and deeper into understanding the litigation analytics in state court. You could tell a lot from understanding opposing counsel. Are they prolific, but maybe don't fight often or ever to trial? So that just knowing that early on in a case can really help your client understand, well, what's going on in this case and what is the best strategy? So that's a quick one. Is this a prolific opposing counsel but has actually never taken a case to trial in this court? Or do they fight? So
that's it. It's a competitive advantage is what I'm hearing. I'm a sports fan, and we may have some listeners that have followed the NFL, and Bill Belichick is one of the, he's a renowned coach. He has many, many, many years of winning national championships. And a big part of his success, I've read, is his willingness to just dive into the data and understand. And much like, as you were explaining how judges may have responded to certain situations or cases in the past, that gives attorneys in the future great insight to possibly make better decisions on behalf of their clients, just the same as likely Bill Belichick and their team may evaluate referees, umpires on the field, and diagnosing ultimately what are all the circumstances at play here and how can I leverage them to the benefit of my client. Is that fair? Is that a fair comparison on what you're suggesting with using the data?
Definitely. So I'll continuing the metaphor. So I'm not sure what the right kind of penalty call might be in a football game or some aspect of how a referee rules. But if the judge ever grants punitive damages, that's huge. That's like a data point, but it's just something to really inform, or attorney's fees. So that's the kind of thing to keep in mind. It's data, but it really anchors your perspective when you go onto the field or you go into their courtroom.
That's good. Well, let's pivot just a little bit, because I know a lot of our listeners here at LAWsome are marketing attorneys. They're consistently advertising, putting a quality brand out there to the marketplace. But one of the big challenges is often, which clients do we accept? Which clients do we turn down? Which clients do we refer out? How can data help attorneys find the right clients for them and ultimately help them kind of qualify and determine which cases to accept?
All right. So Tanner, I'll take that in two parts. First, talking about finding the right clients. So that's where winning new business. It can be as simple at looking at the client list, for a peer firm. And that's something that information is right there in the court record. And so you can look at it in aggregate for a peer firm. Who are they representing lately and maybe historically? And then thinking about whether you might do a better job for those potential clients. And that's something, for example, Lex Machina, for any law firm, you can see their client list. And then setting up alerts for new cases. If you have a potential client you know of, if there are new cases filed, is one way on the defense side to know that there is potential new business and that you could compete for it. Let's see. And then on really, this is more of a big picture, but keeping track really of parties involved in litigation recently with peer companies to one of your clients. Like they might face a similar lawsuit. So keeping an eye on trends as well is really important for sort of across an industry, or really, I use the word peer company, but it's pretty straightforward to keep track for a particular company if they have new filings. So that's sort of diligence on behalf of your client about a potential matter that might be coming their way because it happened to one of their peers. And then the second part of your question has to do with determining which cases to take. And so that's a really interesting question. So you can use data to look at attorney's fees awarded in a particular district for a particular case type. But then also early on considering whether an alternative fee arrangement is feasible and how to come up with a plan that makes sense to your client and makes sense to you. You can use data to really map out what a fee arrangement might look like by understanding the duration of a case, what might happen at different time points, and then working that out with your client.
Got it. And taking that same theme, if you will, in terms of using data, what about competition? Is there a way that you can use data to understand legal competitors in that respect?
Well, maybe I'll ask you to take a step back from that question. Just first ask the question, which of your competitors is using data? And so whether the last time you had a pitch, also which of your clients will use data? Because you don't want your client or your adversary to have better data than you. So starting from that. But in terms of helping attorneys understand their legal competitors, compare your experience with your competitor, you as an attorney or your firm, so that you understand how you stack up when it comes to outcomes, experience with key jurisdictions, different milestones along the way. There are all kinds of means to describe using data your experience, whether it's total cases, whether it's experience in front of a particular judge, and like I said, with getting to different phases of cases as well. So keeping touch with really their client book as well. If you do have competitors, time and time again, watching the volume of the cases, which of them were high stakes, and their venue experience, really keeping tabs on that.
That's good. That's good. And I'm just gonna keep firing away, because I think there's so many different angles here that clearly attorneys, specifically litigators, can utilize this data. But let's talk about the other side of the courtroom. Your opponent, the opposing counsel, or maybe the opposing parties. What data points specifically, Carla, matter when trying to better understand those opponents in the courtroom?
So I think a lot of it comes down to anticipating what can happen in your case by understanding what's happened before. So knowing really the opposing counsel and their track record is a key part of that. In preparation and really working with your client along the way and understanding what winning with this opposing counsel will look like. There may be a negotiation just going on, in parallel to what's happening in court. So understanding really the duration of cases that opposing counsel typically has. Do they end pretty quick? Do they continue on and on? So that discussion with your client about what it looks like to win is anchored by history, really. And it's funny, I was in a conversation with a number of really high-level partners in an industry that's very high stakes. It was a construction conference. We were on a panel together, and I was the data person. And they mentioned just how valuable, in my section, we were showing outcomes for contract cases. They just mentioned that a simple anchor, like how often cases settle. It's something that, especially in litigation, it's easy to lose sight of. The goal is to get the best outcome, to win, typically a negotiation rather than in the courtroom. And so just using data to kind of continually anchor, well, we're at this phase and what's going on with your client is one way really to find success. So reminding them, well, this is what opposing counsel's done before, and we don't have to keep fighting unless you want to. And opposing counsel, they may handle high stakes cases, but it doesn't look like it. They get out pretty quick. Most of their cases don't endure too long. So really managing client expectations around settlement, or how to get a case dismissed. So that's where you can look at opposing counsel's track record and the opposing party.
That's good. We've talked across a few different ways, obviously, to guide case strategy and to better inform. We know preparedness only helps, and I think it would be helpful if you can entertain this for a moment, Carla. I'd love to dive in specifically to individual practice areas, just to hopefully maybe spark some ideas or thoughts for our listeners. So going with that mindset, if starting with personal injury attorneys, maybe handling insurance litigation, how can they find a competitive advantage with data if you have any ideas for those?
Sure. So with personal injury and insurance, one can look to the federal courts as a data set and the state court as well. There's a lot going on in both major sort of venue types with regards to personal injury. And so that's important to mention that as a personal injury attorney, handling claims, those first party claims by the insured against their own insurer, for example, that attorney can learn a lot from legal analytics in cases like theirs against a particular insurer. And if those claims were denied, really what happened in related litigation. So assessing the history on what that insurer has done in federal court and in state can be very insightful because there's probably quite a volume of litigation, quite a rich data set. So understanding the outcome, for example, of automobile policy cases, that's something that can be very powerful in terms of analyzing cases that went through to summary judgment or to trial. And the kinds of data to look at, really, no matter what the legal claims at issue or the fact pattern really that relate to the policy, but the district or the state court venue, the judge, and then certainly time to litigation and damages are all really fertile areas for finding useful data for personal injury.
That's good. Would you see mass torts or product liability cases needing maybe different types of data, or maybe those types of attorneys should be asking other unique questions?
Oh, that's a really interesting pivot, Tanner, because it's very different. And practice area to practice area, the most valuable data to an attorney can really differ. And so with product liability and mass torts, understanding the expert witness and discovering rulings on admissibility, that's a big one. That's huge. And then for an area that could potentially involve that multi-district litigation where there are a lot of cases, and then a master case, understanding the judge track record if a case is part of a master or multi-district litigation case, and then just looking at counsel that do manage a volume if it is some sort of MDL matter, and also the non-MDL mass tort. So there's a lot to learn from data there. Definitely very high stakes litigation.
Yes, for sure. And so let me pivot even further on you and go across a couple other practice area verticals here. What about bankruptcy attorneys? How can they use data if you have any ideas for them to get better results for their clients?
That's really interesting. So I'll take one step back. So Lex Machina is currently developing a module for Chapter 11 bankruptcy courts. So our team has been thinking a lot about bankruptcy and how we're going to bring legal analytics to bankruptcy, because we started early days at Lex Machina with a very analytical practice area. We started with patent, that's technical invalidity infringement, and now we've expanded into all areas of the law in federal court and state court, and then bankruptcy looks totally different. And so it's everyone, we interview a lot of thought leaders and practitioners, and they are very quick to explain, well, it's an extended, ongoing set of negotiations, really around working with many different players, working with the judge, the creditors, the debtor. It's very interesting in terms of thinking a little bit differently about how to leverage data for bankruptcy, but looking at motion outcomes, doing really intensive but smart document search across this volume of cases that happen in the bankruptcy courts. So really, it's this whole new universe for us and for those practitioners. It's a great opportunity to search across all cases and looking really at those key phases of this ongoing negotiation, working in this framework, the bankruptcy framework. And so judge familiarity, both in the key venues, because there are some major venues for bankruptcy court, but then also that less commonly handle a bankruptcy. So just how familiar could judges be with certain kinds of bankruptcy, or your type of bankruptcy, if they're more accustomed to handling Chapter 7 versus Chapter 13, for example, Chapter 11.
Makes sense. And to round things out, for those who are listening who may be in employment law, what about employment litigation? Any advice there?
Well, that's a really interesting question, because there what comes to mind is sort of two modes. One, really tracking new decisions. Right now with COVID-19 related litigation, there's a lot of eyes watching the courts as they rule on certain claims for the first time. And tracking new decisions is a really big one. For example, the EEOC says that employers can mandate a vaccine. And so right now, I just have to open the paper. I think the headline I looked at this morning is all about how the courts are applying disability or religious reasons exceptions to that mandate, and really trying to understand how things are going to play out for employers and employees given COVID-19. And that's something we've been tracking avidly to understand for employment, because there's so many different kinds of claims for employees there. And then, and then the employment, so stepping back from talking about COVID-19, but as a defense attorney, being really informed on your judge. It's sort of like a ongoing, it's always always fashionable to know how much liability you're looking at. It's a key question, just average prior damages, and when you're speaking with your client, really using objective what's happened before as a floor or ceiling, to talking your client through decision making along the way with employment litigation, I'd say. And then because there are so many aspects to employment litigation, looking at data in really meaningful ways. There are all kinds of different sub-classifications, different laws, different statutes. So taking a look at the data sets really keenly and following for your venue. And as we talked about, the different players, judge, attorney, law firm, party, what they've done before for employment is very relevant.
Really good information. That we're all seeking a competitive advantage, and it's clear that litigators, if they're not using data to drive strategy to support their clients' cases, then clearly there's a real opportunity for them. So I'm grateful for you jumping into the hot seat here, Carla. Hopefully it hasn't been too bad for you. But I would like to ask you, if you could step into my shoes, what's one question that you would have asked yourself, maybe that I didn't?
Oh, maybe perhaps sort of that how to get confident in using analytics, or to how one as an attorney, so anchored on your client and your case at hand, how to really get into using the big picture. And that's where I would say think about it as history. A lot of attorneys are history buffs and, always studying precedent, but just really considering that data or that data set is what's happened before. And why wouldn't you want to know what's happened before and have all the information for counseling your client, for making decisions, for winning business? So just get excited about using data. Think about it as history. It's like the ultimate history of everything that's happened before for that judge, for that party of interest.
Any closing thoughts or advice that would benefit either legal professionals or those listening?
Well, I think ask questions. If there is any kind of hesitancy around, which data to rely on or how to get started, is just honestly ask questions and explore what options are out there for your venue. That's my big question, is to use data. That's my advice, I guess.
I love it. What's the best way for listeners to contact you, Carla?
Well, so Lex Machina has a really great website. The URL is lexmachina.com, and you'll find there a contact us button, and then also a lot of really great resources, data sheets, videos, links to reports. We have a blog. We regularly publish really comprehensive reports on various practice areas. Our next one is trade secret, but just the best way, I think, to contact to me is through the site. It's just like the contact now button that'll get to me and to my colleagues who would definitely want to fill you in on what's out there and follow along as we comment on the blog.
Very good. Thank you so much for joining us.
Thanks for having me, Tanner. I appreciate it.
LAWsome by Consultwebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.